Welcome to the University of Western Sydney School of Law. We have with us today former Justices Coleman and Collier from the Family Court of Australia, who are adjunct professors here at the School of Law, and both gentlemen have agreed to undertake a range of topics by way of a conversational style entitled Views from the Bench. And it gives me great pleasure on behalf of the Dean and my colleagues here at the school to welcome both these gentlemen to the school, and we look forward to a fairly lively and engaging conversational style. The first topic we were going to look at was the introduction of alternative dispute resolution into the adversarial system. Gentlemen, what are your thoughts in relation to ADR?
I think it serves a very useful purpose. Of course, in the family law jurisdiction, it is compulsory at the beginning of any process. Certainly, if it can avoid putting people through the expense, both monetary and personal, of 3, 4 or 5 days in court, it is to be embraced. It also has the advantage not only of avoiding those things, but enabling people at the end of the process to feel that they've had some real part in reaching the resolution that they're going to go forward from.
Yes, I'd agree with all that. 95% of all civil litigation is settled without a judgment. So it is logical, I think, that there should be an emphasis on ADR training, when the reality is that 5% of the training on adversarial advocacy skills and court procedures is employed. 95% of the ADR skills are employed. The other thing that's interesting, I think, for practitioners such as David and Paul and I, who've been around a long time, is to think back to the evolution of ADR. What has happened over the last 40 years, I think, is important and worth reflecting on briefly, and that is that 40 years ago we had what were known as round table or settlement conferences, and they typically would take place in the chambers of one counsel, usually the senior counsel in the case, or in the solicitor's office, usually the senior solicitor in the town in question, and you'd have a go at settling the case. That worked very well. It was good for its time, but it really was sort of the horse and buggy era of ADR, because what's happened since is that it's evolved into, it's still not a science, but it's far closer to being a science than it was then. And it's important because I think the science has developed in relation to what works and what doesn't with ADR, how you do it, how you don't. And it's been informed by a lot of social science and a lot of research in relation to expectations, outcomes and aspects of the adversarial system. So it's interesting to think back to 40 years ago and where it's come since then, through the pioneering era of Sir Lawrence Street and others, through to the highly regulated stage that it's reached today. But it's certainly been probably the most significant development in the practice of law in the last, I would say, the last 50 years.
I agree. It has recognised the statistics that Ian's given you, that for 5% of the cases, people are taught advocacy and other skills, whereas for 95% of the cases, we are just now, I think, on the threshold of providing a proper basis for students to go into practice with that behind them. There are various forms of ADR, of course. There's completely voluntary ADR. The Family Law Act imposes the requirement on people, in most cases, to go to a family dispute resolution conference. So far as monetary matters are concerned, the court was fairly advanced in having what were called then registrars' conferences, if you remember it, where a registrar of the court would speak with the parties with a specific view to seeing if they could reach a resolution before the matter went any further. It's something that now, if we didn't have it, the courts would simply bog down. They could not handle the number of cases that are coming into the system. Unfortunately, the great majority are diverted by ADR.
I think it goes beyond the courts just not physically being able to handle the caseload and extends to the vast majority of litigants just simply being unable to afford to litigate. To give an example, the reason I was late here this morning is I've been in a contested notice of motion in the commercial list of the District Court, a case where one party claims $500,000, there's a cross-claim for $500,000, it's common ground, the trial will take 10 days. If that happens, senior counsel on both sides, if it happens, it won't matter who wins, neither party will win, the lawyers will win. So there's a very real cost impetus to try to settle via ADR. And the cost of an ADR event is generally, to use the colloquial, peanuts compared to the cost of going to court. The other thing, picking up what David was saying, is in the Federal Court, the Supreme Court and the District Court, the combination of the Commonwealth legislation in the Federal Court, the reasonable steps notice that the applicant and respondent have to file before commencing or when commencing proceedings in the Federal Court, provisions of Section 56 of the Civil Procedure Act 2005 in New South Wales create a very real cost risk, in my view, for parties who turn their backs on ADR at an appropriate time. We'll probably talk about when is an appropriate time to embrace ADR during the course of the day, but it's not optional anymore, and courts are only going to become more and more insistent, for a variety of reasons, that ADR be embraced. One is that, as David said, courts just can't cope with the caseloads. That's partly without being political about it, partly because appointing judges, by and large, other than to criminal jurisdictions, seems to be a fairly low profile priority for state and federal governments. Secondly, litigation is more complex than it ever was before.
That's correct.
And the costs of getting to court are such that every year going to court and proceeding to judgment becomes an option that is available to fewer and fewer citizens of this country. In corporate litigation, where the stakes are massive, one case may tie a judge up for a whole year in the Supreme Court or the Federal Court. So that's in effect one less judge available to deal with cases of ordinary citizens. So ADR is not a panacea, and we'll talk about it has its limitations, there's no question of that, but we'll talk about those, I imagine, during the day, but it's here and it's here to stay, and it's moved on from being going to a room like this, sitting down with some avuncular former judge like my learned friend here, or some has-been old barrister who smiles and everybody spends a few hours going backwards and forwards and wander off with the settlement. It doesn't work like that. It's moved far beyond that in ways that we'll talk about, but it's a huge part of the litigation process. Maybe counterintuitive, or seem counterintuitive to say that ADR is part of the litigation process, but it is. It's a very important part of it.
Ian, can I just take you back to that example that you made where you've been this morning, and obviously appropriate ethical and confidentiality issues, be mindful of that.
Absolutely.
You say that potentially both sides are claimed and counterclaimed of a similar amount. Senior counsel are engaged, no doubt juniors, solicitors, etc., and judge time 10 days coming up. Where's the obligation now from the bench perspective to ensure that ADR principles are fully explored so the parties are given every opportunity to canvass and consider a resolution, thereby addressing some of those issues that you've canvassed?
Good point. The short answer, Paul, is that the parties won't get a hearing date in that matter until we either tell the judge we've been to mediation. The judge won't just say, oh, that's good. The judge will want to know when the mediation was held, with whom it was held. Judge can't go beyond that, obviously, or it potentially breaches the confidentiality of the mediation. Or alternatively, the judge will want to know in very great detail why we shouldn't do that. But the short answer, Paul, is in that case and in the federal court and in common law and equity, unless you've been to mediation and in the we'll talk about the family provision list, Justice Hallen's list in a moment, but unless you've been to mediation, you don't get a final hearing date. That's
So it's
how
part of case management of the work.
it is.
Now, both of you were practicing barristers before you were elevated to the bench. In terms of that concept of what we're talking about now, about the introduction of ADR in the adversarial system, both of you were very effective and competent advocates in the adversarial system when you were both at the bar.
Isn't he nice?
I hope we had a moderate degree of skill.
Well, I'll make a disclosure here of potential conflict of interest. I briefed both of you when you were at the bar prior to going to the bench, because both of you were competent and capable practitioners. How was it that when you went from the bar to the bench, how did your mindset evolve from being on one side to being on a different side in the context of ADR? Where was that evolution for you?
Well, I'd like to think that I was and am a barrister's barrister. That is my skill, if I have any, lies in analysing cases, preparing, identifying strengths, weaknesses, and in the light of that trying to settle or not settle, let the other party come cap in hand to settle. So I have to say the transition for me was quite simple, and my view was and remained till the day I left the bench, that I was not there to do ADR from the bench. That the judge's role was not to try to bring about a settlement. By the time cases got to trial, they'd been through so many ADR events. And if they had competent counsel, they would have had so many informal attempts to settle that it wasn't appropriate for me to, I considered, to suggest that. My settlement speech was always call your first witness. If they don't have competent or reasonable practitioners, all the attempts in the world to try to, from the bench, to get them to settle will fail. But I think, rightly or wrongly, my perception was and remains from this side of the bar table that it's not the role of judges to compromise their position as the adjudicator by putting their toe in the water of ADR. That's all been done before it gets there, and there's a grave risk that if it doesn't work, the proceedings are vitiated before they really begin in earnest, because inevitably, if the judge does give any hints, they're favourable, more favourable, or are perceived. They may not be. Actually, they may be straight down the middle. That's not the point. The whole thing is the perception of the litigants. And if one litigant perceives at 10:05 on the first day of a 4-day trial that the judge is more favourably disposed to the other party, then those proceedings are fatally flawed from the beginning.
Would you have those same views if there was a self-represented litigant?
Even more so.
Yes.
Even more so.
Can you expand on that, John?
I'll let David and then...
How would you do that? Because this is a real issue for many of our students coming to terms with this age where there are many more self-represented litigants before the courts now, and how are they treated, dealt with, what are the expectations of your views from the bench in that regard?
Self-represented litigants are a very difficult species of litigant. There are, in my view, basically two types. There are the people who simply cannot afford representation, and that's usually because they're too rich for legal aid, or legal aid is not applicable for them, for example in property proceedings, or they choose to be unrepresented because they feel that without someone getting in the way they can run the case exactly as they want to and do what they want to. It is always difficult when you have an intelligent unrepresented litigant before you. If you are, as some of the cases indicate we are required to do as judges, in a position where you're giving them not advice on the case but pointing out matters procedural to them, you're immediately doing that which Ian referred to. You're giving the other party some cause for concern. I've paid a lot of money for my silk to be here to run my case, and the judge is running the other person's case. They generally do not have happy conclusions. Litigants have to be fully informed of how to run a case, as best we can do that. They have to be encouraged to stay on point most of the time. They have to often be stopped from going over the top. One of the things that I found was the delight that some parties took when it came to cross-examination of the other party. And this was where they were going to let it all hang out. These are people that generally are not prepared to compromise. If certainly they've got to you as an unrepresented litigant at the start of a trial, they've gone through all the processes that they've had to go through, and by and large, in my experience, and some of this is anecdotal, they have simply shrugged it off. I want my day in court. If they can be taken into ADR, and if they can be seen, or if it can be demonstrated to them what the pitfalls that face them are, then sometimes an agreement or a settlement can be reached. But of course, remember, a litigant in person doesn't have that major concern of legal costs. Their time, yes. The fact that they're going to be exposed to cross-examination, yes. But by and large, they are usually there because they've been determined from the moment the action started, they want their day in court. Can I just add one further thing going on from Ian again? Ian mentioned what he referred to as his settlement speech. Some judges were renowned for doing everything they could to have parties settle. The reasons behind that were many and manifold. But in so many cases, in my view as a practitioner then, it started the whole thing so badly, because even though the motives in giving such a speech were, look, I really think you'd be better off settling this matter, the parties could easily come away with the concept that the last thing the judge wanted to do was hear that particular case. And that did the judiciary and the system no good at all.
Do you think that the administration of justice is better off with this adoption of ADR as now part of our the adversarial system itself? It forms part of an umbrella. Are we better off as a community? In a sense, are we getting better justice, better outcomes? Are the needs and interests of the parties who come before the courts, before the judges, are they being better served?
I think the answer to that is undoubtedly yes. So with one possible proviso, and I think it's very, very much the exception to the rule, and that is that some ADR practitioners are, I think with respect to them, a little bit results driven. If ever I meet an ADR practitioner and in the first few minutes of meeting that practitioner, he or she tells me about his or her 90% success rate, I personally become a little nervous that perhaps that there's a little bit more leaning. That raises this issue, which we'll probably talk about at some point, of the divide between facilitative and evaluative interventions by mediators. But no, look, it is, because the other thing that I think is important to understand is that particularly in commercial matters, ADR is not an all or nothing outcome. Often you won't reach complete accord. In many cases, because, and it's done deliberately, in commercial mediations, you never have people there who have the authority to make binding decisions. It's always got to go back to the board, so in case on further reflection they want out and so forth. But it does often lay the foundation for a subsequent resolution, or reduces the issues for trial. So it's, and often, I mean, a good mediator will say, ladies and gentlemen, we're not going to resolve this dispute in its entirety. Along the way, it does appear that such and such has been pretty much, at least tacitly, agreed. Can we at least resolve today that as the case goes forward, that issue ceases to be controversial? And that may well be a significant factor in partnership disputes, corporate struggles, things like that. Yeah, so we're dealing with commercial people who understand incremental resolution. It can, so it's not an all or nothing.
Just as comment on that, if I mention to you Donegal and Stevenson, to me as an academic here, I'm concerned that if we necessarily do away with the adversarial construct of resolving disputes and we simply adopt an ADR approach, there's the potential that some of the groundbreaking cases in which we rely upon, that sets the common law that we see is the fabric of how we go about doing what we do, could be lost. So how do we get this balance between ensuring that there is a role, an ongoing role and function for the judge to determine matters of law, but perhaps the alternatives to deal with some of the needs and interests of the parties? Where's this balance?
It would be unthinkable in my mind if anybody were to ever suggest that ADR replaced adjudicative determinations. That's unthinkable. But I think the critical thing is that it comes back to the quality of the mediators. If the mediators, it wouldn't happen. Whatever you've got a robust, independent legal profession, it won't happen, because no matter how anxious a mediator is to secure a resolution for whatever reasons, lawyers will say to clients, look, I respect what you just heard said, but I have to say that they don't know what we've got forensically to undermine the other side's evidence. I think you'll do better in court if it's not a factual dispute.
Yes.
It won't. It will never replace, perish the thought that it would ever replace adversarial litigation. It's just one of the tools in the armoury.
Did you, when you were on the bench, the two of you, did you ever have a feeling that there were matters which you were keen as a lawyer to have a go at and sort of would like to resolve if the matter came before you, but the realisation was the parties resolved their dispute and therefore you didn't get a chance to consider the legal implications? Were there, from a personal perspective, do you feel like that?
Oh, often, you get interesting trust cases, Corporations Act, and what's now Section 18 of the ACL. Yeah, but look, the end of the day, if the parties settle, they settle. There's always somebody out there coming through the system who'll provide the case that clarifies the effect of issue provisions. Yeah. So no, that's not. I don't think that's an issue for judges.
And following on from what Ian said, ADR can never replace litigation.
No.
It may move it down the ladder, if I can call it that, and make it certainly the last resort, which it should be.
Yeah.
But to say ADR will take it over completely means to me, by implication, that you are bringing in a system which compels parties to settle.
Yeah.
And that just can't be. You can try, you can use all the skills of people like Ian to persuade them and demonstrate to them how a settlement can be advantageous to them in their best interests. But you can't say to them, right, unless you agree, that's the end of it. There always has to call it a safety valve, call it a point of last resort. The litigation has to remain in the system.
Absolutely. And there are a whole lot of reasons for that. But one of them that I think David would agree with, having lived through it, is just what attempts to supplant traditional common law legal determinations by judges with enforced settlements. The consequences of that, I think personally, and will continue to believe, were largely referable to the bombings and killings at the Parramatta Family Court in 1980, because with hindsight, what the well-meaning late Justice Watson tried to do was, as in David's words from a few minutes ago, to see every case settled. Every case shouldn't settle, or I put it badly. Not every case should settle.
Not every case can settle.
No. Very often, and this comes up in ADR, very often the legal issues are secondary to the personal or emotional issues, and it was revealed with tragic consequences. What happens when you say to people, look, I'm not going to hear your dispute in accordance with the common law of England, which has worked pretty well for hundreds of years there and for a couple of 100 years here. I read the papers in my lounge room last night. I know what should happen here. This is what's going to happen. Go out and settle.
Don't bother standing up, Mr. Coleman.
No, the consequences were tragic, and I have and apart from anything else, once the traditional judicial approach was restored, those events ceased, notwithstanding that violent and emotionally very overwrought people continued to be litigants in the court. So perish the thought, and ironically, I think a lot of counsel who were around then would agree that the unwitting legacy of the late Justice Watson in Parramatta at least was that litigants after that time were given judicial determinations at a level and of a quality that they'd never had before during the period in which...
I remember that day in which the court itself was actually bombed.
Yes.
I actually had a case on that day.
Yes.
Very tragic.
And there are some litigants who need a judicial determination, no matter how hard a highly qualified mediator works, and no matter how forgiving the other side is prepared to be, up to a point of reason. There are some people who require somebody to say, this is what will happen. I don't pretend to understand the psychology of it, but there are some people who will fight very aggressively with you as the judge. But when a judgment is delivered, they accept it, or at least appear to, and move on from there. And they are people who could never be fully accommodated, withdraw fully, who could never be accommodated in any form of ADR, be it compulsory, be it voluntary, or anything else.
Well, gentlemen, in summing up, could you just in a few words, each of you, indicate how you sort of feel that the adversarial system has benefited by ADR, the introduction and the application of ADR in your time on the bench?
Well, I think, going back to an earlier point, it has made the running of the courts that much easier, because accommodation of the number of cases that would otherwise have to be given simply isn't there. I think it also, in good mediation, focuses the parties on what the real issues are. They needn't be legal issues.
No.
And often, as you say, they're not. But good mediation, even if it's not successful, focuses the issues. It can shorten matters very considerably. And it can give people a proper opportunity, if they're willing to explore it, to settle a matter in a situation where they have a fair degree of control over what the final outcome is.
I agree with that. Yes. I concur and have nothing to add.
Well, gentlemen, on that note, thank you very much for the first in a series of reviews to the bench. Most appreciate your time here today.
Thank you, Paul.
Pleasure, Paul.